Welcome to Clause 8. I'm Eli Mazur, and I'm lucky to be joined today by Gaston Kroub.
Gaston Kroub.
And you are the founding partner of the IP litigation boutique Kroub, Silbersher Kolmykov, and the patent advisory firm Markman Advisors. But you probably know him from reading his columns on Above the Law. So thanks again for joining us.
Thank you, Eli. Good to meet you.
So I thought a good place to start would be really to talk about Above the Law, since that's where probably a lot of people know you from. I remember when I first started reading Above the Law, it was really focused on big law and specifically raises and bonuses. There was a slogan they had, New York City to 180, I believe. And then the coverage quickly turned when the Great Recession happened to layoffs. So do you remember when you first started reading it? Where were you in your career? What was your impression of the legal industry at that time?
I may be dating myself, but I remember when the slogan on Above the Law was New York to 125.
Oh, wow.
So we're going back. But yeah, no, really, I think I've been reading Above the Law since it started. I was a fan of the Underneath Their Robes blog that David Latt, the editor-in-chief, had put out. I always like reading about judges, learning about judges, and remembering that they're people was always interesting to me. And then once I was fortunate enough to get an associate position in a large law firm in New York City, it was, a natural continuation to learn about the industry I was in, which was the New York kind of big law world. Above the Law really filled a big role in terms of allowing associates to communicate in a very indirect way, but understand a little bit more about the business they were in, their standing within that business, and just gave people more information about topics that I think had been relatively closed, especially to younger lawyers who were still more of an employee than an owner. So Above the Law, I think, is something that I've kind of grown through my career with. As the years went by, I was fortunate enough to make partner. The focus on associate salaries became less important, but it was always kind of on the to-read list on a daily basis in just terms of keeping up with the industry nationwide, which is important, especially for patent litigators like myself who may be based in New York, but really have had a national practice their entire career.
Do you remember when the Great Recession happened, what you were thinking about in terms of the legal industry? Were you an associate at that time, or were you already a partner?
I was fortunate to join the law firm that I did, Greenberg Traurig, when I did in New York. It was really an up-and-coming office. I think the headcount doubled from when I started till about 3 years later. And then at some point, the New York office actually became the biggest office in the firm, both in terms of headcount and maybe even revenue, which was a big transition for a traditionally South Florida firm, but also that had spread internationally. So in that atmosphere, there was a lot of excitement. There was a lot of changes. It was a constantly moving environment. I like to say that one of the most interesting parts of my early career as an associate is that, to a large extent, almost every patent case that I worked on was the first case that Greenberg Traurig's New York office was doing for that particular client. On the one hand, it was exciting because the firm was maturing, the IP practice in New York was maturing, and we're bringing in bigger and bigger name clients, particularly in the software and technology areas. But at the same time, it still had this feel of, this is a New York white shoe law firm, and had those expectations on associates and the infrastructure to support it. At the time of the Great Recession, which I'll put at like 2007, 2008, fortunately for myself personally, I was a little bit insulated. I was clearly under the gun. I was elevated to counsel in 2008, which is kind of the stepping stone at Greenberg to making partner. But I knew throughout that period that I was being watched in terms of potential partnership. So my hours had to be where they needed to be. More importantly, it was very important, especially in a firm as broad and deep as Greenberg, to make myself known outside of the New York group. And this is advice I give to associates in any big law firm. A lot of times, the people that can really make the difference between you making partner or not are those lawyers in those other offices that you do one or two projects for. If they're happy with what you do and they're willing to speak up for you, that goes a long way, because everybody kind of expects the lawyers that you're always working with to advocate for you. Obviously, if they're at the partnership discussion and you spend 90% of your time working for one or two lawyers and they're kind of sitting on their hands, that's not a good sign. But every little bit helps. And people people that are able to kind of make a good impression on lawyers in other offices or in other practice groups and have those people advocate for them, that can really go a long way. So I was fortunate in the sense that I was still very busy in 2007, 2008, going into 2009, and the door to making partner was still open, at least for me. That was my personal experience. At the same time, I was very much aware that it could really be a very narrow thread. I had one big case that was taking up a vast majority of my time. Obviously, I would stay busy on other matters, but having that one case for a paying client, high stakes litigation where I was the day-to-day counsel, senior associate, whatever you want to put me at, was obviously critical towards me making partner, staying employed, and, being in good graces. So, you see around you and you see a lot of capable lawyers that maybe don't have that fortune at that time, and you understand what a sometimes brutal business it could be.
Was there that stress that big case can settle anytime?
Yeah, I mean there always is. There's always, particularly where as an associate or as someone up for partner, where you can't even get your name brought up around the table unless your hours are where they need to be. Obviously, that's really important. I mean, and then I think by that time in my career, 2008, I was had already been married for 7 years. My third kid, who was my daughter, was born May of 2008. So it was a time for not only progressing on the professional front, but also the recognition that you're not 25, 26, 27 years old anymore. You're a breadwinner for a family, and thankfully a growing family. So a lot of things contribute to the load on the shoulders. But that's a good thing. It depends how you react to it.
That's definitely a good attitude.
Yeah.
I guess we'll dive more into your background because I think it's journey that you took is really interesting. But before we get there, I want to talk a little bit more about your columns on Above the Law. I was going back through them and I was amazed the output. It's almost every week you have a new idea. First of all, how do you come up with so many ideas and how do you stay so disciplined in order to stick with it?
It's a good question. So, I mean, I was fortunate to have been given the opportunity by David Latt to work on a column for Above the Law. As with anything else, it took a while to get into it, but at the same time, I always appreciated David's management of me in terms of making clear what the expectation was with respect to output, and I was able to quickly settle into a routine. So originally, my column was called Beyond Big Law, and the focus of the column was to talk about what it meant to be a relatively young big law partner who was leaving to start his own firm with a new batch of partners and give it a go in the big city as a boutique shop. And that provided a lot of very interesting fodder. I mean, it was very easy, especially early in the process, to write about the more mundane things of practicing small law after coming from a big law background, like finding office space or working with LegalZoom to get our corporation set up. There was a lot of naturally basic transitional type discussion that I could have about all these new experiences that we were having. At the same time, I also felt there was a little bit more freedom. Now that I wasn't a partner at a larger law firm, I could talk about things that I had experienced. I could talk about the news of the day and really come at it from a different perspective, having gone through the partnership gauntlet, spending a few years as a partner, lateraling from one firm to another as a partner, and now with respect to this new endeavor. So finding the content is never that hard. What took more time was to stick it into my routine, which I've done. Over time, it's like anything else. When you start working out or you start doing anything, once you develop the routine and you find the space in the schedule for it, magically the schedule expands to accommodate it, because it's been at least 4 or 5 years, maybe even longer. And I follow the same process. I'll keep a note as ideas come in. I used to use Evernote, but sometimes I just write them down. On my personal Google Drive, I have all my old columns. And whenever I come up with an idea, I just outline it. Takes a minute or two. And then usually if it's a slow Friday afternoon or a Sunday morning, I'll draft a column. Sometimes I'm up against the gun and I'm writing the column late Monday night because that's when they're due. And then part of the writing process is to develop a rhythm with it. I try to follow the same structure for a lot of the columns. I know the paragraphs should be shorter rather than longer. I mean, you're still writing for the internet, so you're trying to keep in mind the audience. And I just follow the same pattern. I'll write a draft. I'll put it aside. I'll come back to it, make some edits, send it over over to the editors, David Latznolorg, and my editor, Stacy Zaretsky, and she does a great job too. And I see my column on a Tuesday, and now I'm at the point where I have to remember, like, tweet it out and, get it out there. But I feel fortunate to have the ability to share my thoughts with people. And whenever I get feedback, it's really nice. At some point, though, the whole conceit of the column of talking as a former big law partner, as a new small firm owner, kind of got a little stale. And by mutual agreement with David, we transitioned the column away from that focus, though we do bring up those issues sometimes, to more of an IP-centric focus. As part of Above the Law's broader mandate to try to develop subject matter expertise, and there's a lot of very good IP writers on the site as well. So going back to how you started this, right? Above the Law was known for one or two kind of core things, but I think over time the site's matured, it's become broader, and there's a lot of really fantastic content that I'm happy to contribute to.
Your column has a personality. You talk about your personal preferences and opinions. Do you ever worry that your client or a potential client might not like what you say or disagree?
So I'm very careful. I am an opinionated person, and I do have, I would say, a very strong personal direction in life in terms of what my priorities are, how I try to govern myself, how I spend my time. But I think within those strictures comes the freedom to express myself in the way that I want to express myself, while also remembering that I'm writing for a general audience, that I do have client responsibilities. I have responsibilities to my partners. I have responsibilities to Above the Law. And I think a big part of it is I'm not looking for controversy. There's no benefit to me as a writer, as a person, to stir the pot. Rather, I feel like part of what my responsibility to my readership is to open the door on things that maybe aren't necessarily discussed. One of the things that I keep on coming back to lately is this idea that in intellectual property disputes, 95+% of cases end up settling. And I definitely understand the ethos of we have to prepare every case for trial. And, that's how you win, is by getting to the point where the other side is just ground into dust. And I've done it and I know how to do it. And there definitely is a time and a place for it. At the same time, I also feel like intellectual property lawyers need to do a better job of conditioning themselves and their clients for settlement. And there's different skill sets that come into play that aren't necessarily taught because maybe they run counter to the financial incentives of the law firms that are litigating these cases. At the same time, we know that judges love settlement and do everything they can to force the parties to settle. So I think there's complex issues that we can talk about the nature of the practice that we're in, where it doesn't necessarily have to be controversial. It just has to be open and transparent. And I think that's kind of what I strive for. The other point I'll make on my writing style or on whether or not there's an element of danger to it is to say that one of the fortunate things that I've been able to do since leaving the big law kind of milieu, even though we really haven't, because most of our cases are against those types of firms, and we're very comfortable interacting with them and litigating against them and litigating with them, that it hasn't really been beaten out of me yet. But this whole focus that we have at Markman Advisors, where we're working with investment professionals, whether it be a family office or a hedge fund, and handicapping patent litigation for them, and learning all those rules about avoiding insider trading, avoiding disclosure of material non-confidential information, and seeing the professionalism that these investment people, on the one hand, accumulating as much research as they can on a topic and really exhausting what's available because they never want to miss information. It's valuable, while at the same time trying to remain above board and doing everything they can to make sure that they're not given anything that would prejudice their investment or prejudice their fiduciary duty to their investors. That has helped us, I think, or helped myself also recognize how careful you have to be with each word.
Yeah. The ethos that you
It's at the end of the day, we're in a service business. I take very seriously the idea that the only thing that matters is our client's interests up to the ethical limits of everything, of course. And it's the hardest thing to do sometimes, which is to ask yourself constantly and consistently, is this what's in the best interest of my client? But it's also the most rewarding aspect of the process when you actually crack that code, do the right thing, get the result that may not have been apparent when you started. And that can carry over into writing a column for a general audience as well. I mean, sometimes all you have to do is highlight the issue or frame it, You don't even have to fall on one side or other of the line. And I think that in and of itself can be a service to the readership.
One of my favorite columns of yours is about how lawyers shouldn't speak negatively about themselves. I'm not sure if you recall that one, but can you tell us a little bit about that idea and how you came up with it?
One of the adjectives I've used in the past to describe our profession is brutal, which is a harsh word, right? And as patent lawyers, we love words. We understand how words convey meaning. They can really be valuable to the extent that they're in a claim. And, if interpreted one way, it's worth zero. If interpreted another way, it's worth $1 billion. So we're very comfortable understanding the power of words. And brutality in the legal profession, I've seen it extend to the way lawyers treat themselves. And it bothers me. It bothers me because I've fortunately been around a lot of very intelligent, caring, dedicated, hardworking people. But there is, unfortunately, a tendency among lawyers to feel like they never really measure up. There's always someone out there that's on a better case, that's making more money, that has more prestige, that went to a better law school, that did better in torts, that is going to have an article published. For an industry that relies a lot upon pedigree in terms of sorting people, it can be difficult to maintain a sense of optimism and maintain a sense of self-worth, and to understand that not every contribution can be measured in the immediate sense. And sometimes things that you do for a client don't pay off for years down the road. So to me, knowing that we're in a very difficult profession, knowing we're in a demanding profession, knowing that it's the type of profession where people ruin themselves physically and mentally in the pursuit of what they think is success, why handicap ourselves? Why put yourself in a position where you're speaking negatively about yourself, particularly in front of other people? If you want to stand in front of the mirror to motivate yourself and say, you're an idiot today, or learn how to dress, or whatever you want to say negative about yourself, if you're using it to motivate yourself, go for it. That's not what I'm talking about. What I'm talking about when I say lawyers shouldn't speak negatively about themselves is in front of your family, your parents. They're proud of you. They have a child that went to law school and is working as a lawyer. They don't want to hear what a loser you are. Your spouse, they've made a choice. You've made a commitment to them and they've made a commitment to you. They want to know that if you're not successful yet, you're on your path to success. Your children, same thing. They need hope. People need hope. People need to believe that they've made the right choices in terms of associating themselves with somebody. And I think that extends to your partners, your colleagues, and especially your clients. No client wants to hear from their own lawyer what a screw up their lawyer is, or how the lawyer could have done a better job. You're getting paid good money to do your best. And I'm not saying that we're always in a position where we're doing our best and everything we do is perfect, but there's no sense in harping on it. There's no sense in seeding doubt in your client's mind or in your colleagues' minds about your competence. And unfortunately, I feel like sometimes lawyers have a tendency to do that in an attempt to humanize themselves.
Yeah.
But personally, I feel like it's a big mistake. I think if anything, lawyers should be spreading optimism, should be looking for solutions, and never casting themselves as even a potential problem. That's kind of something that's important to me.
Yeah, I think that's really interesting and good advice, but probably takes a little practice actually following.
Look, there's no lawyer that hasn't had dark days, right? There's no lawyer that hasn't overcome some level of adversity to get to whatever position they're in. I don't care who you are. I don't care whether or not you were an A student from when you were 3 years old and everybody said you're going to be the next Supreme Court clerk. You're going to be the first kid from this town that's going to clerk on the Supreme Court. You know what? At some point, someone's told you no. Someone said you're just not good enough. You wanted to work for this justice and you couldn't get an interview in that chambers. Yeah. And you could obviously go all the way down the list to people that have a lot more to overcome. So we all face adversity. We're in a profession where people are coming to us with problems and looking for maybe not even answers, but at least help in dealing with them. And I think over time, when you get over the fear of failure, you realize that there's no sense in handicapping yourself or in spreading even an element of distrust in your competence or your commitment to the people around you.
So I want to go back to your story a little bit.
Sure.
As you mentioned, I think you eventually became a partner at Greenberg Traurig. Is there anything you wish you knew in the beginning of starting to work there that you knew by that time? Is there anything that surprised you by the time you became partner?
I'll say it this way. I'm a first generation American. My parents were both born in Egypt. They both came here relatively young, went to college here. My father's an electrical engineer. My mother has a master's in education. So, even though they were immigrants, they came with a level of education. And obviously in the old country, there's a longer history of my family being professional or being among the educated. So the expectation was always that education was important and that I would gravitate to a profession. Growing up, I always thought I was going to be a surgeon. I liked the idea of being able to work without having to talk to anybody and also really making a direct impact on somebody. That didn't really work out in the sense that when it came time in college, even though I had great experience interning at NYU Medical Center with the urologists and got to see how they went about their day and how they dealt with patients and the research that they did, the time commitment to medicine looked too much at the time. So I ended up taking the LSAT and deciding to go to law school. I'm not ashamed to admit, at the time, I honestly knew nothing about the legal profession. I knew that there was something called law school, which you go to. My uncle's a lawyer, and he had gone to law school here. I have lawyers in my family going back generations.
What kind of lawyer is your uncle?
He never practiced.
Oh, okay.
That's the typical, immigrant experience. He came, he went to college, went to law school, and went into business with my father. So that's, that happens. So I was really going to be the first in the family to try to make it in what we call the big law environment. But going into the process, I knew nothing about it. And one of the things that I take responsibility for now is I don't mind if people make choices, but I prefer them to make informed choices. So whenever I have the opportunity to speak to younger people that may be interested in law, I try to encourage them to educate themselves, and to the extent I can help, I try. Educate themselves about the profession, about the business. If someone was going to tell you, look, you have to go and open a store on Chicago's, Magnificent Mile, and that's going to be your career, you're going to learn all about it. You're going to learn about the rents, and you're going to learn about whatever it takes to going into opening a store. But I feel like a lot of lawyers, they go into law school to go to law school, but they don't really know much about the business. And for better or worse, I think law schools don't do much other than setting up on-campus interviews and things of that nature. So in terms of looking back as a partner at where I was as an associate, and really taking a step even further back, I think if I were talking to myself, and I plan on doing this with my own children, all right, look, understand that it's a profession and it's wonderful to have an education and it's wonderful to know all you can about adverse possession and, attractive nuisances and all the stuff you learn about in law school. But at the end of the day, this may be your business, and it's going to be a business of one, right? For, basically your entire career. No matter who else you associate yourself with, if your head's not right and no one wants to call you and talk to you about what you know about the law, you're not really going very far. So I always wish that I knew a little bit more. But at the same time, for me personally, everything worked out. And despite the fact that I kind of did everything with a very high degree of difficulty, because maybe if I had spoken to myself more, I may have said, you know what, you should have gone for your master's degree and tried to gone to a higher ranked law school, taken another year, go to a higher ranked law school. Well, you were rushing to go to the first school that'll take you and offer you a scholarship. Same thing with getting into big law and starting. I was a summer associate at a Boston-based firm, and I was not a very good summer associate. I'm not ashamed to admit it. But the point is, in this profession, you have to learn from your mistakes. You have to learn from the adversity. And then when you get that, sometimes you have to fight and claw to generate that next opportunity. But once you have it, you have to take full advantage of it.
So I think that leads us to the next question I had. Eventually you moved to Lock Lord. And I'm sure there's a lot of associates out there who are getting calls from recruiters all the time. And they'll always think, well, maybe it's better somewhere else. Is there any advice you could give about how one should evaluate when making such a decision, and whether really moving from one big law firm to another big law firm really makes a difference?
I think it can make a very big difference, and it can make a good difference for the best, and it could make a difference for the ill. And I'll say it this way. If you're in a big firm environment, or even a larger boutique, or somewhere where your ambition is clearly to make partner and your fate is going to be the hands of some group of people, right? You better be the favorite of someone with a say in that process if you are going to have any hope of progressing to the next level at a particular firm. And there's a lot of factors outside of maybe even your legal ability or your personality that determine whether or not you're going to be the favorite of someone that matters. By very nature of things, your fortunes are going to be tied to the pull of the person your wagon is hitched to. And sometimes those persons' fortunes can rise or fall. So I'll say it this way. If you're thinking of moving firms and it's not something where you've gotten married and you made a mutual decision to move to a new city, where that's great and that's kind of a lifestyle change, or you've been told that you have to leave, which happens a lot in law firms, and then you have no choice. But if you're sitting pretty, you're productive, you're well thought of, you're comfortable, you can shake it up, and it may be a great thing to shake it up, but you better have a plan, and there better be a purpose, and you better be as sure as you can be that the firm that you're going to sees value in you and is going to be invested in your success as much as you're invested in your own. Because I've seen lateral lawyers come into a new firm and flourish. And I've also seen lateral lawyers come into a new firm and kind of wither on the vine through no fault of their own. Yeah. You're introducing yourself into a new dynamic. It's almost like, if you want to use a sports analogy, you could be a great first baseman and you might have an opportunity to go sign as a free agent for the Yankees and make more money. But if they already have a first baseman that's starting on a bigger contract than yours, you're basically putting yourself on the bench, which may be okay, because at some point, it's not unheard of for associates to say, look, I'm just going to squeeze out whatever additional money I can out of this rotten lemon, and then I'm going to do what I really want to do. Yeah. Your ambition kind of matters. The place you're going to matters. And I think it's important for people to realize that it's as much of a commitment as deciding whether or not to break up with your girlfriend. Give it that same level of care.
You touched upon it, but I think you said that eventually you realized being a lawyer at a big law firm is really a business of one. It was interesting. By the time you went to Lock Lord, you were already originating all of your own work. Can you tell us maybe the story of how you brought in that first matter, and how did you really learn to do business development from that point?
I was fortunate. Greenberg was a very exciting place, particularly the IP group. I would say between 2002 when I joined and 2009, there was a lot of energy. It was very much a full service group in terms of we were doing pharma litigation, we were doing software litigation, we were doing e-commerce cases were also hot. There was a great mix of clients and a lot of lawyers that had all come together at Greenberg, and were all motivated to generate business, to keep the momentum going within the group, to get the next big client and to keep the ball rolling. So being even an associate in that environment, there was always the sense that, of course, you're going to do business development. No one has to tell you to do it, because you want to have control over your own career and you want to be contributing. And it's not just about sitting in your office and closing the door and working from 8:30 in the morning till 10:30 at night. It's also about going out there and getting to work. And I remember my first client was actually a kind of small business that was a family friend. They had a trademark issue. And I was really mentored through the process by one of the trademark partners at Greenberg. Obviously, it was a small matter. It wasn't going to be a lot of money. But people like him took the time to walk me through the mechanics of opening a client, preparing bills. It's the kind of thing that once you get a taste, you want to eat the whole hamburger. Yeah. And, business development in general can be very frustrating in the sense that you could spend a lot of time on it and you might think you have such great things to offer. And nobody wants it, at least initially. And then just a continuous process of trying to make the best of what's available and making the most opportunity, and hopefully being in a position where clients are satisfied and, are willing to stick with you. I think I said this in one of my columns. The value of a lawyer can be directly measured by the number of people for whom that lawyer would be the first phone call when they have a legal problem.
Good way to put it. Yeah.
All right. So you could be the greatest lawyer in the world, but if no one's thinking about you when that case lands on their desk, or that employee threatens to take down the whole IT structure of the place, or whatever the problem may be, that doesn't matter. What matters is who's calling you up. And as an associate, one of the most helpful things we were taught at Greenberg was that in the beginning, your clients are the partners you work for. You do good work for them, they're going to keep calling you. There's no shortage of work, and they'll keep calling you, and you satisfy those clients. And then at some point, the transition starts to happen where you start developing clients of your own. Then you learn that, the same level of care and attention you give to your partners as your clients, you have to give to your actual clients. It's a continuous process throughout your career of kind of maturing and understanding that the mix may change, but the level of attention and commitment, and going back to what we talked about before, placing their interests first, that never changes. That's the constant, right? So if you're an associate, you kind of have to have your eyes and ears open. And if your partner told you, mentioned off the cuff in the summer that they're really looking forward to their Thanksgiving vacation with their family, and it's October or late October, early November, if you care about that person, you're going to be going to them and saying, look, I know you've got vacation coming up. Is there anything we can get a jump on? What can we start doing just to clear the decks? Look, it's not your vacation. You could be as jealous as you want that when you go on vacation, you go for, a weekend in the Poconos and they're going on a yacht in the Bahamas. You could have all those feelings. Those are normal and natural. And if they motivate you, they're great. But at the same time, you have to remember you're working with other people and your job is to make their lives easier. And guess what? You do that for somebody, it's going to come back on you tenfold in a positive way because they're going to remember, like, this is someone that cares about me, so I'm going to care about them.
So in terms of business development, would you advise just mostly doing good work for existing clients and then those people remember you later on? What has been your experience to become that first person they think of?
Before we started our new firm, and we were, weighing the decision of whether to leave the comfort and safety of a larger institution to go out on our own, we realized that there was a very specific market niche that wasn't being filled. At the time, and this is, I would say, late 2012 to 2013, there was a lot of interest in the market in what they were called PIPCOs, publicly traded patent operating companies. I don't know how they got from there to get to PIPCO, but whatever. The point was that there was a host of these publicly traded companies, typically small or micro-cap stocks, which had acquired or had a homegrown set of patents, and they had this huge lawsuit that they had against the named company. So the one famous example is a company in Florida called Parker Vision. They claim to have invented some kind of technology on chips, and they had this $1 billion case against Qualcomm. And they had McCool Smith was their counsel, and this was going to be $1 billion or bust. And you have a publicly traded vehicle for investors, whether they be hedge funds all the way down to retail investors, to put their money, kind of place your bets. Guys, the casino's open. Yeah. If you think Parker Vision is going to succeed, this is a company you want to invest in. You're talking about a potential 10x return on your money. And, at the same time, you realize that if they lose, there's nothing there, right? It's just a bunch of patents. So there was a number of these companies. There was 5 or 6 well-known ones. There were more opening every day. And there was really a sense in the market that this was the next frontier, that there were all these patents that were out there, that all you needed was someone who was savvy about patent litigation on your board, find good patents, find the nice juicy target, a Google, a Qualcomm, or whoever you want, someone with deep pockets, set up the entity, and the investors are going to rush in because why own one lottery ticket when you can own a piece of 10, right? Yeah. So that was the mentality. And we were fortunate, me and Serge Kolmykov, my partner, we had an early meeting with someone at a family office. Locklord was right here downtown New York City. We took the train to Midtown. We met him over a pizza lunch. And he was telling us about this publicly traded patent company called Viringo that his family office was invested in. And there was a lot of attention in the case. The case was going to trial in Virginia. And the stock was jumping up and down. Every time there was good news, the stock would jump up. Yeah. Every time there was bad news, the stock would jump down. And that kind of whet our appetite to look more into these issues. And what we realized was that there was a lot of investor interest, both from sophisticated institutional side, but also people that were selling their second car to buy $10,000 more of Parker Vision stock. And no one was really giving people accurate information. And in fact, a lot of the information that was being put out on websites like Seeking Alpha and some of the other business sites were flat out wrong. And worse, people were making decisions based on this wrong information. So we said, all right, we know about patent litigation. We can review this patent. And, even though it was on our time, we said this is a business development opportunity. Let's tell people what patent litigation really is like. And we started writing on Seeking Alpha. We started getting meetings. We got meetings with investors. We got meetings sometimes with the companies that we were writing about. Right. Like, oh, you guys look like you know what you're talking about. Maybe you could help us. And really the whole Markman Advisors business was built on this idea that the investment community benefits benefits from knowing about the mechanics of patent litigation, and that us as independent yet still active patent litigators know the playing field, know the judges, know the different courts, know the litigants, sometimes know the lawyers, not necessarily in a personal way, but just we're within that world, and that we can give good advice based on non-confidential information. It's like the mother lode for investment professionals. We have no access to anything confidential. Right. We're not on the case. We're not the lawyers on the case. We could just go on Pacer like everybody else. But maybe when someone else downloads a 70-page summary judgment decision off Pacer, it takes them a few phone calls to their patent lawyers and maybe breaking their head over a weekend trying to understand it. Whereas we're at the stage of our career where we could scan in 10 minutes and give a client advice on, hey, this was good, this was bad, this was, somewhere in between. That ended up being valuable skill. So going back to the question, I do encourage people to obviously do the work that they can as best as they can for the people that matter. But when they think about business development, also keep an eye out. Maybe there's some, an interesting new niche that isn't being filled. And that's where maybe you can add your voice. So step one is to educate yourself about the niche and about the audience. And then step two is to start generating content and getting yourself in front of people. And between our articles on Seeking Alpha, between our Twitter presence, we did a symposium with Dan Ravisher at Cardozo Law School on kind of IP investing for what Wall Street needs to know about investing in IP situations. And I'm very comfortable saying that there are a lot more people that are potential clients at sophisticated entities that know Markman Advisors more than they know our law firm. And that's fine with us. It's good to be known for something, but you have to build it. You have to build it from the ground up, and you have to realize where the customers are.
Is that why you set up Markman Advisors as a separate entity, kind of so the financial customers can relate easier to that?
First of all, Markman Advisors already had kind of a brand name. I mean, the rule in New York is that law firms have to have the names of their partners, and KSK is kind of a good shorthand, but there's a ton of much, much, much more well-known law firms that have been doing business in this city for hundreds of years. So standing out as a new law firm, particularly at the stage of our careers where we were still relatively young, was not going to have the same impact on the market as Markman Advisors did. One of the things that was interesting about marketing as Markman Advisors is we have a very dedicated potential client base, right? We're not trying to market Markman Advisors to patent litigation clients per se. We're focused very much on a very specific segment of the investment community, and that is a self-contained world. And your reputation is only as good as the last project you did or the people that are willing to vouch for you. So being able to go to that community with a name and to build that name through continued business development on Twitter, through articles. Now we have a Markman Advisors blog. For a year, I did Markman Minutes, which were short video clips on patent litigation situations. Really trying to keep that brand front and center was, I think, very important for us. At the same time, where one of the things that we're marketing is the fact that we are still active patent litigators. There are services out there where you have retired lawyers or people that are full-time on this market advice business. And obviously, anybody on the sell side or buy side could go to any IP boutique to hire them to handicap a case. Right. And I had that experience at Greenberg. It was a tobacco case, I remember, and I was handicapping it for a hedge fund. But I think one of the selling points we have as Markman is the fact that we are active litigators. At the same time, because of the regulation in the financial industry, because of the importance of discretion, because of the importance of making it absolutely clear that we have no access to non-confidential information on any of the projects we work on as Markman, having it as a separate entity from the law firm was very important. The other aspect to it is now that we're 5 years into this varied endeavors, Markman has become a little bit broader than just consulting for the investment community on patent litigation situations. A lot of times we're also doing monetization type consulting for existing patent owners that may have patents that aren't really doing much. They need people that understand the NPE landscape, that understand the kind of the corporate defendant landscape, and help evaluating. So it's not per se legal work, so it doesn't fall under the umbrella of the law firm. But everything we do is informed by our core competency of, a deep understanding of patent litigation and comfort explaining the mechanics of it, and also at the same time being able to dig deep into the actual technology at issue and come up with ideas and guidance based on the actual substance of the technology at issue as well.
And I think you said some of the big entities that are being sued also have contacted you. So do you provide a second opinion service to those?
No. I wish I did. And this goes back to like my above the law column. Yeah. One of the things I think that's missing in the patent litigation marketplace is a robust market for second opinions. I will say, without reservation and without trying to fluff ourselves up in any way, we are a natural source of second opinions for companies that are currently embroiled in litigation. And if anybody needs to satisfy themselves, then I'll commend them to look at the work we put out as Markman Advisors, even on our blog. It's funny, just yesterday or the day before, the Federal Circuit issued its opinion in the CRISPR patent interference dispute, which is a highly watched biotechnology fight. And there was an interference, and the Federal Circuit said there was no interference. In fact, the Patent Office said that, and then it went up to the Federal Circuit. And my colleague, Zach Silbersher, wrote a series of articles on the appeal, kind of in real time. He, I think, wrote one article early on, kind of evaluating the briefs. And then after the oral argument, he listened to the oral argument, and he gave his prediction, opinion on that. And guess what? He nailed it. And it's not a surprise because we've been doing this for the last 5 years. We've been looking at various cases at different levels of the process, whether they be at the Federal Circuit level, whether it be still at the district court. And we've been handicapping them for very sophisticated clients that ask very hard questions. Investors are not, the people that work at these hedge funds, just to use them as an example, these are highly educated, very mathematically oriented, very precise people that take their duty to manage other people's money very seriously. So you could be sure they're as tough as any client ever was. They're as tough as any partner ever was in terms of asking us to substantiate our opinions. And with the background that we've gotten servicing that clientele, there are situations that are ongoing where I think we could actually provide very valuable second opinion level work for not that much money. But again, it's not something that traditionally has been done in the patent space. And, going back to my big law firm days or even at our current firm, occasionally we will be called in to substitute as counsel because the client is unhappy with whatever the prior firm is doing. But that's not the same thing, and that's not as valuable. And that's always an expensive transition and time-consuming. So a second opinion could give clients a lot of bang for their buck.
So was this idea for Markman Advisors really the reason why you decided to go off on your own and start your own boutique?
I think having the energy and interest around Markman was what gave us the comfort to take the leap. And, to be clear, it was a very big leap. At the same time, we would not have done it if we didn't think that we were going to be able to generate money representing clients in a traditional law firm boutique capacity. So at the same time as we were kind of amped up about Markman's prospects, we also felt like it was at a good point in the market to introduce a intellectual property boutique to the New York market as well. Over the last couple of years, we've seen a lot of very prominent and well-known former titans of the New York IP bar merge or get subsumed or break apart. Kenyon, recently Fitzpatrick just announced. So while the market seems to be stratifying towards kind of big law or boutique law, we did look around and say, look, there's not that many firms in New York City that are our potential size to start, but also coming to the table with really deep big law experience.
What was your biggest concern when you started?
Oh, it was going to be obviously how to pay the bills. And we were talking, between three relatively senior big law people. None of us were, at the level where we were 6 years old partners on that level of compensation, but we were all individually making good livings, and obviously your expenses don't stop just because you decide that you want to change change firms. So obviously one of the big concerns was always going to be, how do we generate capital in the short term? But at the same time, I think we were confident that we had a lot to offer the market and that eventually things would work out. Kind of a funny story. One of the reasons we left when we did was I had brought in, together with my colleagues, a semiconductor, kind of a RFID more than semiconductor, RFID client out of Shanghai who had been sued upstate New York, and the case was just getting going. And we had negotiated a favorable kind of budget, and we figured, okay, between the other stuff that we're doing and this case that's about to start heating up, we'll be fine. Right? At least for the first 6 months to a year. And then, as time would go on, we would add more. So, of course, we leave Locklord, give our notice in early November. I think I remember we offered that we're happy to stay till the end of the year. And they were like, no, there's no need. You guys want to go, go. So we declared December 1st our opening date. And we left at the end of November. And not even 2 or 3 weeks later, we had a mediation in this case where we're representing the defendant. And we go up to Rochester with the client, and I went with Zach, and we mediate. And guess what? The case settles that day. So we're like 2 weeks into a new firm. We got one client who we're kind of counting on to really smooth the transition, and we go up and we settle the case. And it was definitely the right thing to do. It was the right thing for the client. It was the right thing for us. It was actually important for us to show that we were going to be able to operate the way we wanted to operate. Right. And settling a case, even when it was quote unquote against our personal financial interests at that point, was definitely the right thing to do. And, I'll be honest, it was like with any business, the hardest stretch is the first stretch. And then you get a break and something good happens. And then it's all about capitalizing on that momentum. I will say, as a small firm owner, we've been fortunate enough to have been in business now for 5 years. So I would say we're established. We definitely know what we're doing, and we're doing the things we want to be doing. That's one of the advantages of having your name on the door, right? Even when the door is not necessarily the same kind of door that it was at a big law firm. The mix of what we're actually generating revenue from today versus what it was 2 years ago. That's one of the most interesting aspects of this business is patent law. And I think patent litigation in and of itself, because when you actually have an active case, they are so big and they throw off so much money in terms of the expenses and the discovery and the amount of legal work that goes into really doing a case the right way. A firm's fortunes can really flip based on 1 or 2 litigations that they have in-house. And that's the nature of the practice that we have.
Somebody who started their own patent litigation boutique told me that an experience that he had is that whenever they're involved in a lawsuit with a bigger client who has a big law firm, what that big law firm tries to do is kind of overrun that smaller boutique because they know they have capacity issues. Have you experienced anything similar? And really, what has changed between litigating at your own boutique versus litigating at a big law firm where you had theoretically unlimited resources?
We definitely have experienced at least some points, and particularly in certain contentious situations where it's less the lawyers on the other side and more the clients on the other side, kind of a dismissive, almost indignant attitude in the sense like, who are you to be suing us, basically? And that's happened. Thankfully, it doesn't happen too often. In my experience, it doesn't necessarily always happen in a vacuum. There's always a lot of factors other than just the fact that we're a smaller firm that go into creating that dynamic where, the people on the other side of the case are looking to bury you or, in kind of scorched earth mode. Yeah. I would say that one of the ways we avoid it, and actually one of the freedoms of, again, operating a smaller boutique, is that we can really get to the heart of matters in a case very early on in the process. And we are not shy about bringing that to the other side's attention and calling the other side out on maybe techniques that they might use where it's clear they're putting their interest above their client's interest, right? So if we get the sense that a law firm is looking to litigate just to generate billings, right, and it's not really advantageous to us or them, if the time comes and our client has the ability to tell their client what's going on, we encourage our clients to be frank with the other side and say, look, we think your firm is giving you the old runaround treatment where they're generating an invoice the size of a manila folder that can't even hold it. So like that's kind of something that I think we have the freedom now to be very direct. We're not in the business of wasting time. We're busy enough that we don't want to be wasting anybody's time, whether it's an existing client, potential client, opposing counsel, someone on the other side. I think what's happened with experience is that we are a lot quicker, use an example of a potential client coming in and saying, look, we have this patent. Do you think it's litigation worthy? We're a lot quicker and a lot more decisive 5 years in than maybe we were in the beginning in terms of being able to say, look, no, this isn't for us. This might be for somebody else, or this is for no one. Your patent is horrible. Whatever the answer may be, as you become more established in the market and confident in your own competence and wherewithal, you can be more direct. And that extends to interactions with opposing counsel as well. If I'm in a case where there is a resource imbalance and as a result, I'm going to be constrained in terms of being able to defend my client, I'm going to let the other side know that. I would fight you on this motion, but my client can't afford it. But then it's not enough to just say that. You have to flip it. You have to turn it into an advantage for your client and say, look, but we're going to let the judge know that we've been trying to settle this case and we think this case would benefit from early mediation. And now you've taken a weakness and you've at least started to plant the seeds that maybe this is something that could resolve quickly. And again, we were all trained and we were all experienced in terms of preparing cases for trial. And nowadays also preparing IPRs on to or fro, depending on what side of the patent you're on. But at the same time, the reality is that the vast majority of cases settle. And one of the freedoms we have as a boutique firm is we can be as laser focused as possible as to how do we get to that beneficial settlement as early in the process as possible. Sometimes that's not possible. Sometimes the earliest in the process you can get the beneficial settlement is after you win an IPR after a year and a half. That's fine. We have patience. But a lot of times by being direct, understanding the substance, understanding where the pressure points are in the litigation process for both sides, we're able to drive results quicker.
I think it's somewhat a related question. From a perspective of a sophisticated in-house counsel, you have a, choice to hire a boutique of partners of at least the same caliber as other big law partners who you know are going to be focused on your case 100% versus hiring a big law firm where your case might get pushed down to who knows who. How do the big law firms compete against IP litigation boutique?
There's the traditional answer, and then there's what I think is going to be the more modern answer going forward. The traditional answer is that, look, no one ever got fired for hiring Kroub, right? So if you're an in-house counsel, yes, your primary duty is to your company, but people are human and no one wants to be the one to take the risk. No one's going to put their livelihood at risk or their family's livelihood at risk to take a chance on the upstart boutique unless there's really good reason to do so. So there is still that ethos, and the big firms do still benefit from the idea that you hire a large firm because there's safety in that. There are also benefits sometimes where certain litigations where if the other side is going to be intimidated, seeing a large firm on the other side of the docket, that might be official. At the end of the day, it has to be a holistic, thoughtful decision by in-house counsel. And sometimes it's made under duress in the sense that they have an existing relationship with a firm so they can't even open it up. Other times, and we've been experienced with this, beauty contests and let the best firm win. So there's a lot that goes into it, but I do think that one of the challenges as a boutique firm is to rise to that challenge and sometimes convince somebody that they should take a chance at you. At the same time, when you're in a boutique firm, sometimes you benefit from the fact that certain matters just aren't appropriate for a large firm, whether it become a conflict issue, whether it because of whatever, something else. It's just they don't have the capacity or they have too many of those types of cases. And a lot of times big firms don't like to give business, as going back to a baseball analogy, you don't like to trade players within your own division, right? So it's a lot better if you're in New York and you play Seattle twice a year. Trade your player that you have to get rid of to Seattle. Same logic applies sometimes where we'll have former colleagues at a big firm be like, look, we don't want to give it to a big firm down the street. We want the client to understand that we're the ones, advising them, but, we think your firm would be a good fit for this case. So there's a lot that goes into that client selection dynamic. And as a boutique firm, you just try to, jump on the opportunities that present themselves. I think the less traditional approach or direction that the market may be moving to, particularly with respect to patent litigation, is the injection of litigation finance into the picture, which is always maybe one of those things that may have been around for a lot longer than people think, but has really started to pick up in earnest. And we've lost cases or potential cases where the client or the potential client said, look, this other law firm already has litigation funding in place. We're going to go with them. Even though we're fortunate, we do have relationships with a lot of funders and we understand how to prepare a case for litigation funding. But now you have another constituency in the mix. And by the way, this is the constituency that actually has the money, which everybody wants. So it's an interesting dynamic that I think is going to develop over the next 5 years, maybe 10 years. And that really could shake up the landscape. There definitely are litigation funders that are interested in partnering with smaller boutique firms to get that level of attention and commitment and personal touch on their cases. At the same time, there are definitely litigation funders that are more than willing to go to large firms and say, look, use your brand recognition to attract good patents or good cases, and we'll fund them as well. So no matter where you are, I think wherever you fit in this litigation landscape, litigation finance is one of those areas that has become much more important for people to be familiar with, to develop relationships within the industry, and to just wrap your head around the fact that the traditional attorney-client relationship may not be changing, but it's going to be impacted by an external factor of some consequence.
Going back to when you started your boutique, I guess the advantage of becoming more senior at a big law firm is that you get to kind of push down the more menial legal work to junior associates. How were you able to mentally adjust to the fact, well, now you're going to have to kind of have responsibility for doing all the work?
I would say that personally, I was always very hands-on, and we're formed by the people, by our professional mentors. And I always had the good fortune of working for people who were very hands-on. The trial lawyer that I trained under, he would write the briefs himself, even though he was a senior person. I would get to craft an argument. We would sit in the room together and generate something. But I was always exposed to people that took a very personal interest in the work and enjoyed doing the work. So I would say that when I kind of left Greenberg and went to Locke Lord, I got a little bit better in terms of delegating and being able to work with other people. And I would say that at KSK, we've never really been in a position of having the sense that any one of us is doing all the work, because we are so collaborative. I mean, the firm was really founded on collaboration, people of equal levels doing an equal level of work and maybe getting to focus on the things that they enjoy the most. But from the very beginning of our firm, we've been a cohesive unit, and everything gets run by everybody else. And it really does increase the quality of the work product, but it creates this atmosphere where you never feel overwhelmed. You always feel like there's two other people that have your back, and you're responsible for having their back. And it does make a lot of the drudgery, or what we would consider the menial tasks, a lot easier to do. Thankfully, over time, there's been, I would say, two big developments in our firm that really made that whole process a lot easier. The first is, remembering that when you start a new law firm, you're responsible not only for the legal work, but also for all the administrative work. And we're fortunate that our partner, Serge, is an operations whiz. And he's, from day one of the firm, he's handled our accounting. He's handled our IT infrastructure. These are all things he's naturally good at. He enjoys. I'm sure there's times where it's annoying for him, but and we do pitch in, we do create our own invoices and things like that. But having one of the partners willing to step up and really take ownership of one aspect of running the business is incredibly important. The second is we were fortunate about a year in to have the opportunity to hire an associate right out of law school. She's grown with the firm in terms of her capabilities, in terms of her own business development and everything like that. So obviously having an associate that we can work with and mentor and give projects to also helps. And we were also fortunate the first 2 summers, we were able to get summer interns, really well-credentialed people, and they were able to work with us on projects. So I think when you take all those factors, kind of a collaborative atmosphere to begin with, clear delineation of responsibilities, and the help that we have from having an employee and reaching out when necessary to other people, that's kind of the recipe for being able to avoid that sense of being overwhelmed or feeling like we're stuck doing a lot of drudgery that we didn't really sign up for.
So do you rely on contractors, for example? I don't know how much document review there is.
I think our natural impulse is to keep costs down as much as possible, both for ourselves and our clients. So we have used outside discovery vendors in the past. If a case justifies it, we do what's necessary for the case. But I think as an initial approach, we try to make sure that our infrastructure is robust enough to support anything that we need to work on. But again, if we need to go out and hire additional outside vendors, we're happy to do it. And we've also collaborated very well with other law firms on cases and things of that nature. Again, going back to the nature of patent litigation, where it's a national practice, we work with local counsel a lot, particularly in the jurisdictions where we have a lot of work, California, Texas, to some extent Florida. And Zoe, our associate, did take the Florida bar, so that's helpful for us going forward. So we're comfortable working with outside counsel, local counsel, and even working closely with the in-house counsel of clients. Also, one of the things we're seeing now is that clients tend to be more hands-on. A lot of times they'll have real resources internally, and being able to work with them is important as well. I think the key is not to get stuck up on, because we don't have this pressure like you do in a large law firm to cross-sell and make sure that the 32nd associate in Phoenix is busy. It's a lot easier to just say, look, we're open to whatever it takes to get the job done, and we're very comfortable collaborating with whoever we need to collaborate to make it happen.
That makes sense. So I just wanted to end with a few final questions. Sure. Something that I guess you touched upon. You're an observant Jew, and I was just curious about how you thought that has impacted your professional outlook and approach. I don't know if the listeners know, but for example, on the Sabbath, you're obviously not going to be answering your phone.
Yeah, so I've worked 24/6, as they say, for a while. There's a couple of things to come with religious observance in the large law firm context, particularly, where it was absolutely critical to be in an understanding place. So obviously, being in New York helped, where there is a large percentage of observant Jews. There's observant Jews on the partnership level of almost every law firm in New York City. Yeah. And to a large extent, that generation helped pave the way for lawyers like myself in terms of making it clear that no matter your level of religious observance, you can function at the highest level professionally and as a colleague. The other aspect to it has been people have to see that you're sincere and that you're consistent, and this is not something that you're doing for your own personal convenience. And things that go along the way along that front are, basic things like, okay, if it's Christmas Eve, for some reason, every year Christmas Eve, I was in the office, a lot of times doing stuff that we would normally rely on the paralegals to do. But you know what? I felt like it was my responsibility. If there were discovery due and the partner had signed off on it a day or two before because they were leaving, I'm going to make sure that discovery gets out, even though I'm sitting at a copy machine on Christmas Eve, which is technically a federal holiday and a day off. So having that understanding and respect for your colleagues is, of course, important. And then the other is to observant Jews live very regimented lives in terms of each day having a specific structure. And what it leads to, I think, is being mindful of time and almost developing an aversion to wasting time, which serves you in good stead in a profession like this. One of the things I learned early on, I believe it was either Cesar Alvarez, who was the former CEO of Greenberg Traurig, or Richard Rosenbaum, who is the current CEO. They said at one of the firm meetings that, like, one of the things you realize when you get older in this profession is that the busiest lawyers are the happiest lawyers. And they define busiest lawyers not necessarily as those that had the most billable hours, because the expectation is that everybody's going to have a lot of billable hours, but the people that have the fullest lives. And that's something that I've seen in my own life, that having a level of religious observance, familial commitments, my pro bono work, my column. Lately, I started teaching a class in my high school on IP, and that's something that I enjoy very much. I've also become lately much more involved in my child's school. I'm now on the board of the school. I'm an officer of the school. And these are all things that kind of develop over time. And you can never put yourself in a position where you're overextending yourself. But one of the beautiful things about taking a long-term view of your career is to realize, look, all right, in the beginning, my job was to be the best associate I could be, and making sure that my religious observance didn't conflict with that. As time goes on and your professional career matures, you'll have opportunities to add more things to the mix, whether it be pro bono, whether it be family, whether it be some other type of community service. And it's really just about making the time as meaningful as possible.
One last question. What advice would you give to a law school student, or maybe one of your high school students who wants to become the next Gaston, Kroub?
I would say try not to do things with as high a degree of difficulty as I did. And a lot of it comes down to being self-aware, being confident in your own ability, understanding where you may have strengths and playing to those strengths. I think by our nature, a lot of people spend a lot of time trying to correct their weaknesses, where they would be a lot better off by working on their strengths and trying to maximize their strengths. And along with that, I believe very strongly that there's room for optimism in life. There's room for a positive outlook. There's room for, especially for a lawyer, to really take to heart the idea that you're in a profession to serve others, and that serving others can run the gamut from doing something very small for somebody to doing something very big. And you have to jump on those opportunities as they present itself. So my advice to my high school students, or to anybody in law school now, is to realize that it's an interesting profession. It's a challenging profession, and it's not a profession that benefits from people forgetting their humanity. It's a profession that becomes more fulfilling and rewarding the more you remember humanity and do what you can to make your life as full as possible, and share that with your colleagues, your clients, yourself, and maintain that positive outlook, optimism, empathy for others. And when you look back after 10 years, 20 years, you're going to realize that you made some good decisions along the the way and you had some fun as well.
I think that's a good point to end on. Thank you so much.
My pleasure. Thank you so much.